County's docket. That is case number 109083, Jaden Burkhart v. Lacey Willinger.
Please the court, John M. Lindner on the brief and appearing for the appellee, Kelly Burkhart, and I would like to reserve 2 minutes, please.
2 minutes is granted.
This case, as you know, involves a custody order. It is a logical, proper custody order that was entered by the District Court of Finney County, Kansas.
Well, what's logical about a child who's not even reached the age of 2 and making a custody determination based on prospective facts and circumstances 3 years down the road? What is logical? What is appropriate about that, especially when we look at custody determinations are made on facts that are established preceding the hearing and up to the hearing? How could just explain that to me? What's logical about that?
It is logical for the court to anticipate a predictable change in the child's life.
What's predictable 3 years down the road in anybody's life?
I'm sorry?
What's predictable about anybody's life 3 years down the road?
Well, it's predictable that when a child reaches the age of 5, the child is going to go to school. The parents live 250 miles away. It is logical that the child is at that point going
That's
to have to live
350
one
miles
place.
away in 2012. What's to say where anybody's going to live in 2015?
Well, it's a matter of continuing jurisdiction of the court. If something changes, either party can bring the matter back to the court. That's the beauty of the system.
Well, you mentioned that, so, and what you're saying is if they didn't make this order, then when the child's 5, they're going to have to go back to court. That's there has to be a change of circumstance to preclude another change of custody, right? Is that what you're saying?
Yeah, if this order had not been made, then when the child reaches school age, there's going to be another 2 or 3 days of knockdown, drag-out trial. Yeah.
And the only thing that would preclude that is if there were a change of circumstance, so they didn't live 200 miles apart.
Certainly
Which
that.
is the flip of what normally we have, which is you only go back to court where there is a material.
That would be a change of circumstances that the court could consider at that time under the continuing jurisdiction rule, yes. The Court of Appeals felt that this was 2 different custody orders, and I think that's where it all fell apart at the Court of Appeals level. It's only one order. The court dealt with the situation that he was presented with, that the parties brought to him with this 2-year-old child, and then he made an order that operated into the future. The district court maximized the time, the parents' time with or the child's time with both parents by continuing the equal time order that they had agreed to while it was possible, and then anticipated a predictable change in the child's life and made the order for the school age order and designated a residential parent. All custody orders operate into the future and are well within the court's discretion. In the appellee's original brief at page 8, we cited Kansas authority Legrong. I'm sorry. At page 7, yes, Legrong, where the court said that the court may look into the future, and we also cited at page 9 and 10, an Idaho case that was directly on point, the exact same set of facts. Then in our petition for review at page 8, we cited the Smith case, and the Smith case followed Perry and followed Johnson, and stated there is nothing within the statute limiting a district court's authority to anticipate a significant change in the life of a child and plan for that change accordingly. We conclude the district court here was clearly within its discretion to anticipate a predictable change in the child's life and fashion an appropriate residential custody order accordingly. Now, ironically, that was Smith was a 2004 case, and that order was made by the same district court, the same district judge. And in that case, the Court of Appeals reversed because the judge made no findings as to why he chose, why he selected one parent over the other for the residential parent at the time that the child went to school. In the case at Barr, the court made substantial findings, and we quoted this at page 9 of the petition for review. The judge said, "This selection is made due to the wider support group available in the Garden City area for the child, the school system, and the child's acclimation to Garden City over the last 2 years. The father's family support seems to be solid and consistent and better able to give the child everything she needs as she grows into her formative educational years." I think that's very well reasoned, very well thought out.
And he made those future findings based on today's facts. I mean, he made that prospective August 2015 order based on what he heard during the November trial.
He heard from, I can't remember, 15 or so witnesses, and yes, he heard that the father had very strong family support. He heard all of that.
From what statutory authority does a district judge's authority arise that we can make future custody orders like that? Where's that authority come from? Does it come from 233213A6? Or does it come from 233218, which is the change of circumstances statute? That's what the Smith court, Brungart court cited, was the change of circumstances statute, and they said there's nothing in there that precludes us from doing this. But it seems to me you're hanging your hat on the permanency plan statute, the permanent parenting plan statute, that A6 provision.
Well, I believe that the findings that the court made are all well within the purview of KSA 233203. The child's acclimation, the family support, everything that's contained in that statute, and it seems that the case law, the Smith, following 2 other cases, seems to just very clearly pronounce that the appellate courts of this state feel that this is appropriate for the court to anticipate changes in the child's life and make those orders, because otherwise, I mean, frankly, parents would be...
You're talking about anticipate known changes.
Yes.
When you said all orders are future orders, I assumed you meant we make a determination today what the circumstances are and whether it's best for the child, and we simply assume those circumstances will continue until someone alleges a material change in those circumstances. But you're saying that doesn't apply when we know today that the child will go to school at age 5.
Yes.
But we don't know today whether the father's support system will change. And like with any other order, we look at what it is today and we just leave it there until someone tells us it's changed.
That's correct.
That's what you were trying to say?
Exactly. You come into court on a custody determination, you get the custody determination. It is going to carry on into the future until someone under the continuing jurisdiction rule brings it back to court saying this needs to be changed. And if the court, under the facts presented to the court, knows logically that there is going to be a change in the child's life that needs to be dealt with, like school age, then it's perfectly proper for the court to go ahead and make that part of the custody order. And I believe that the courts have said that several times.
Is that true? If, I mean, we're talking again, as I pointed out initially, we're talking 3 years down the road here. He's projecting that, one, the child's going to be ready for school. We don't know that. But just based upon what typically happens at age 5, you go to school, could the judge said, well, then at age 12, he or she will be ready for middle school, and I'm going to make this change based upon successful completion of the elementary school experience, and then we're going to look at this, and time's going to change, and the custody's going to change 10 years down the road. What's the difference in doing that? Could the judge do that?
Well, I'm not sure I followed the question as to
The
why
question
those.
the question is how far along into the future can a custody order be, and a change in custody based upon projected changes.
I think if it is not a projected but a predictable and logical change, then I think the court can deal with it.
Regardless of when it would occur in the future.
Well, the simple answer is yes, but it would have to be a logical change, and there would have to be some nexus.
You can project all kinds of things. There's all kinds of mischief that could occur here. You could say, well, when the child reaches adolescence or puberty, I think it's going to be more appropriate that he or she is with a different parent based upon the bodily change. All kinds of things that can be predictable down the road, but you just. I just think we're in very dangerous territory here when we try to predict here based upon just speculative changes in
I don't think there's any speculation here. I think most kids go to school, and if this child for some reason would not go to school, then either party could bring this back before the court. And once again, I think that's the beauty of the system, the continuing jurisdiction over children until they're 18 and have graduated from high school.
Is the difference that you're trying to make is the logistical impossibility of the current scenario working versus the personal interaction problems. In other words, you're saying that logistically, when the child goes to court, you can't have a shared custody
Right.
200 and some miles apart. Is that what your
Yes.
argument is?
Yes. Both families testified in this matter, and the court made a determination as to what he felt was best
Was there any
from that
dispute?
standpoint.
Was there any dispute that the current system could work when the child starts kindergarten if there are no changes in the current circumstances? Did anyone dispute that it was logically impossible to continue the current arrangement?
As far as the positions of the parties, they were both in court asking to be designated the residential parent, so I would say yes. The court.
I was going to ask, was this judge asked to make this future kindergarten order? Was that suggested to him that we also need you to decide where the child's going to live when she starts kindergarten? Or did he craft that on his own?
Well, no, the order that he crafted was on his own, but both parties were asking to be the residential parent.
Okay.
And one of those components was, of course, because the child is going to go to school, the child has to live somewhere.
So no one even suggested shared residency. He just decided that it was
Well-
appropriate to have shared residency for the next almost 3 years.
Well, that's what the parties were doing, and the child was doing pretty well under that order. At transcript, the trial transcript, page volume 4, the court at the conclusion of the trial spent 5 pages cluing the parties in as to what his order was going to be, and went right through it and explained why very logically. He said, your 3 days here and 4 days here is no longer going to work. You can expect my order to be pretty much equal time with each parent. I'm not going to have the exchange point because you have conflict. So the parent getting the child's going to go all the way, and the child picking the party terminating the visitation is going to go all the way. That's the way you're going to share the transportation. And this is only going to work with the distance between you. This is only going to work until the child reaches school age. And at that point, one of you is going to be the designated residential parent, and the other parent is not going to get as much time as they want. And I'm sorry about that. But he walked. I mean, when he made his order, it was no surprise, because at page 414 through 418, for 5 solid pages, he walked the parties through the structure of his order and gave the reasons.
And one of the reasons were schools in Garden City. Was there any evidence about the schools or what schools this child might even attend? Would it be a private school, a public school, versus the school in the residence of the mother? Was there any discussion about that?
There was no comparison of the schools. The mother's witnesses testified as to the distance from the school. Her residence was close to the school, and that her sister, I believe, ran a preschool, if I remember.
I'm just talking about the schools 3 years down the road. Was there any discussion about the quality of the education, anything about that?
No, there was none. As I suggested in my brief, the court doesn't come to the courtroom with a vacuum of his mind. I mean, he has knowledge of the school system in the community where he resides, and both parties were certainly capable of putting on whatever evidence they wanted to, and both parties were asking to be the residential parent, and one of those components was that this child is going to go to school, and we can't live 250 miles away. One of us has to be the residential parent.
Do we have any further questions of counsel? Would you like 30 seconds to wrap up, or do you think you've made your points?
I wanted to mention the continuing jurisdiction, and I've already done that, and I wanted to point out that this was a fully tried case for 2 days, and the parties have expended a great deal of time and money, as has the court system in it, and we feel that the custody order should stand, and we think it's a proper order. Thank you.
Thank you, counsel.
May it please the court, Michael Whalen on behalf of appellant Lacey Willinger.
Mr. Whalen,
Yes, ma'am.
if the district court had entered an order giving the one parent residential custody immediately and articulated the only factual basis for that there would ultimately have to be something done because when the child started school, this long distance relationship wasn't going to work, and the judge just wanted to get that in place now, would we be here?
If he had relied upon the same findings he made.
No, the only finding he made was that, well, I mean, yes, in terms of why he was picking that one parent over the other.
Yes, we'd still be here. If the finding was because the schools are good which there was no evidence about any schools. It was mentioned.
I think you're misunderstanding.
Oh,
She says
perhaps I
if
am,
the
Your Honor.
finding was based on shared custody will not work because of the 250 miles when the child starts school, so I'm just gonna do it now. Forget about which one. I'm gonna pick the model being residential. Would that be permissible to do it now based on what's gonna happen in 3 years? I think that was the question.
Yes.
Okay. If it was done based upon evidence and the finding of the best interest of the child, after applying the relevant requirements under 233203, an examination, and that statute says the court shall.
I don't think you're getting it. You're saying that the judge can't order a custody arrangement based on what's going to happen in 3 years. The question is, if the judge had just ordered it now based on what's happening in 3 years, what's the difference?
Your Honor, our argument isn't that the judge is legally unable to make such a finding. If they're going to make such a finding, it must have evidentiary support in the record.
Do you dispute that the shared custody, or did you dispute the shared custody arrangements that we have now?
No, Your Honor.
Do you dispute that that cannot continue when, logistically, when the child begins kindergarten?
No, I don't believe that's necessarily true.
Okay,
I believe that there could be a split of schools and supervision. I mean, currently in Kansas, there are a few schools that actually have full-time kindergarten. I mean, there are other arrangements that could be made, and that's something that could be worked out and determined by the parents. Isn't it an automatic?
Would it be the current system?
Excuse me?
Could the current custody order, the way it is now, the way it's operating, logistically, could that work when the child starts kindergarten? Not whether there's another one that could be done, but
Your Honor, it could. I don't have, and there isn't evidence from the record to say that it couldn't. And I think that's really part of the problem, was nobody asked for a determination in the future. No evidence was presented to support a determination in the future. It was completely sua sponte by this judge that he was going to make a future determination. That was not the focus of the parties. There was, of the three reasons the court gave for making this finding, we have the schools. There was no evidence about the schools, the quality of the schools, why Garden City schools are better than other schools in the state.
that's the second issue. The first issue is, can a judge make a future order of change of custody? That's the first issue.
I believe under the right factual circumstances, yes. We're not disputing the ability of a court to make such a finding.
So here it would have been, if your client had received residential custody in this order, you wouldn't be, have a challenge.
If my client had received it, yeah, we wouldn't be challenging it. But, and just a side note that the court should be aware of, as far as the continuing jurisdiction in this case, the district court in this case had refused all motions until this court makes a decision. And there have been changes in circumstances. So I would ask this court to please make a very speedy decision in this case, because it's completely on hold until a decision is issued.
So you agree that there is authority for a district judge to make a future custody order under the right circumstances?
I believe that there can be, because our standard is the best interest of the child. If it can be supported by evidence, and I recognize that nationally that is not the trend. Most states have found that making future orders such as this, or an automatic order, are not in favor, and they're not supported because we can't predict the future. And I agree completely with Justice Rosen that in this case,
But we do predict the future. When we make a
Absolutely.
determination, you say, this is what is happening with mom, this is what's happening with father, this is what happened with grandparents. You take it, the judge can only look at what it is and say, I'm ordering this, and that's gonna continue. We don't know what's gonna change in the future or what it's gonna be, but we make the order and we only change it if there's a material change in circumstances. So we do look into the future. That is future, that's gonna continue.
Right, I'm not in disagreement with that, Your Honor, at all. I mean, we predict the future by looking at the past. But generally, district courts make their determinations based upon evidence. That's what was lacking in this case, was any evidence about why this change should materially happen in 3 years hence. The second issue was the child's acclimation to Garden City. She's 2. I doubt that she's aware of the shopping malls and the nightlife in Garden City. And there was no testimony about her acclimation specifically to Garden City. The only one of the statutory factors allegedly considered by the district court in its ruling was support system of the family. And even that is a tenuous decision because it was proffered that Mr. Burgart's father would provide daycare, but he has some severe medical issues. And that's one of the things that if you look 3 years hence, we don't know what's going to happen. And this judge certainly did not. And the parties were not on notice that they were arguing about the future. And so this was created in a vacuum by the court without evidentiary support, and it needs to be turned down and remanded and allow this case to move forward.
Counsel, I'm not aware that either you or opposing counsel have informed us what you think the appropriate standard of our review is for this question.
Your Honor, the standard of review is abuse of discretion, and I believe in Ward, based on numerous other cases, we look at the fifth, based on an error of fact.
There's not
example-
substantial competent evidence to support findings.
Yes, Your Honor.
And that, as I understand it, is what the the Court of Appeals said in its decision. They did not make a decision on the propriety of automatic custody or residency change orders.
Correct, Your Honor.
So we're here to determine if there was in fact evidence to support the findings made by the district court, and you say there was not, and the Court of Appeals was correct.
That's correct, Your Honor.
And you've listed the only one that possibly may have any evidentiary support is the family support,
Yes, Your Honor.
and you don't feel that that's sufficient to support the judge's findings in the order.
In and of itself, no, Your Honor. But I think what's also missed, if we take a look at the record, I mean, 233203 requires the court to examine the relevant factors. I mean, it states the court shall consider all relevant factors, including, but not limited to. And here, there is no representation by the court and no evidence to support, or that the court reviewed any of the relevant factors that it's required to do. And there was no evidence to support any of the other findings. And I think those are truly difficulties with this case. And I also find it interesting that the Perry case, the unpublished case, it did involve the same district court judge, and that case was reversed and sent back because that court failed to make appropriate factual findings.
To what extent can the trial court provide for the child's changing needs that's subject to a custody hearing? I mean, isn't that what the court's attempting to do here? Just to provide for the changing needs of the child that is predictable in the future?
And it's a
And
noble
there's
goal.
statutory authority for that. I mean, there's tension between the two statutes that provide for best interest, but isn't that what the trial court attempted to do here?
I believe that's correct, Your Honor. And I think I don't think we can say that, no, the child's never going to go to school, and I don't think it's reasonable for anyone to say that the on-off every 2 weeks shared custody program is going to be amenable to the child attending school in the future. But that's what we're dealing with, is the future, and we're going to need to take a look at that time, at the changes of the child, the changes of the parental circumstances, and as to what is going to be in the best interest of the child based upon what's happening near to that time. Right now, we don't have that information, and the court didn't have that information. The court did not solicit information about future placement, and it wasn't an issue by the parties before the court. And yes, the court was trying to probably stave off, judicial economy, I'll make this order now, we won't have to fight about it later. But there isn't anything factually or evidentiary to support that finding. It wasn't the focus of the hearing, it wasn't really the purpose of the hearing.
There's nothing in the record to support the court's notion that because of the 250-mile distance, that it was logistically, at least impracticable, to have that arrangement once the child went to school. You disagree with any basis for that
No, Your
finding?
Honor. No, I don't disagree with that.
And so if that's true, and the circumstances had continued, then the shared custody wouldn't work, and assuming it wouldn't work when the child went to school, then you'd have to file an action to change based on a material change in circumstance that everyone knew was likely or probable to happen,
Well,
right? I mean, that's,
that's a part of it, yes, Your Honor. But what it
so
doesn't
it's
take
really
into
not a
account-
change in circumstances from today's viewpoint, because everyone knew the kid is gonna go to school, at least by first grade, by state law.
But what it ignores, Your Honor, is that intervening 3 years and material changes in circumstances that may
Well,
happen, occur, or come up.
That happens all the time. Then you file a motion for material change in circumstances. What I'm saying is, this turns it on the head. If we know that this isn't gonna work in 3 years, we already know it today. If everything stays the same, this isn't gonna work, then the order is made today, and then you go to court if something changes. But by not making that first that order now, we're going back to court in 3 years, even though nothing changed from the way we knew it was going to be as of today. And so you're actually having to go back to court when there's no material change in circumstances, other than the fact that the child's going to go to school that everyone knows is going to happen. You understand what I'm saying? You're turning material change in circumstances on its head.
But even the child support guidelines recognize that circumstances change as a child grows. And we're talking about the needs of the child at that time in the future. And we're also, Your Honor, there has to be some evidence. There has to be some evidence that would support the district court's ruling.
That's
It's
a
not
different issue.
I-
That's
but
a different
it's not, Your Honor.
issue between which parent is selected as the custodian, and whether you can provide for the logistic changes or the logistic impossibility of continuing the current.
Well, that was Justice Rosen brought up. What if a child doesn't start school at that age? What if she is a late birthday and winds up going another year? Then our anticipated change, we have to go back.
We have a material change in circumstances from what we anticipated right now. What if something happens with mom? What if the school shut down? Those are changes of circumstances from the picture we're taking today, and that fits the purpose of a material change in circumstances going back to court. What I'm saying is, why do we go back to court when we already know today what the circumstances are going to be?
I'm not arguing the policy, Your Honor. I'm not saying that a judge can't do that. I'm saying it shouldn't have been done in this case. That's not our position. That wasn't our argument. It was based upon these facts. The court did not assess the best interest of the child at the time in the future, could not have, had no evidence before it to do so. I'm not disputing, Your Honor, that the court may look to the future and known material changes in circumstances. But I'm dealing with this case and this set of facts. And this set of facts does not support the action of the court. And unless there are other questions, I don't really have anything further.
Well, I do have one more question. What's the remedy that you're after here? Is your client okay with the almost 3 years of shared residency?
Yes, we haven't disputed that, and we didn't bring that
Okay,
up
so
on
if she's
appeal.
okay with that, and if your client, and if you agree that a judge can make a future change of custody order if the facts support it, then what are you asking the court to do? Remand and direct the trial judge to make substantial findings in support of the change order or not? Or retry the case from the get-go? What's going to happen when it goes back to the district court?
We have a valid custody order in place right now. The provision of the future custody just needs to be excised.
Okay. Which means almost automatically that in August of 2015 or the summer before that, you're going to be back in the district court arguing over custody because that child's going to school and 250 miles apart is not going to work.
Judge Ward, my client's waiting to get back into court right now and is being barred by the district court from doing so. This is going to be a contentious, unfortunately, ongoing issue with these parents and this child. And we're not, this isn't, everything between them isn't just stopping for this 3-year period as well. I mean, we're not just all sitting around waiting for the child to go to school and everything is fine and groovy. I mean, the reality is there are going to be more hearings, there is going to be contention, and there is going to be contention about this issue more than likely for the rest of the child until they reach 18. But we have a workable system now, and perhaps over that time period, perhaps the parents can come together and come to an agreement about how they want to work with school age. But let's give them that opportunity and not the court in this case without evidence to support a crystal ball finding of what should happen without evidence to support it. And that's really our position.
Why isn't the support system of the family, which you admit there was some evidence about that, sufficient? Even if we would if we do a harmlessness analysis, even if we set aside the other two, the acclimation and the school system, isn't the support of the father's family enough to affirm the court order?
No, because there was equivalent evidence on the mother's side. The reason that she had moved to Winfield was to be close to her sister, who owns a daycare, lives across the street. Her mother is in Wichita, who is a teacher. I mean, we had a balance of evidence on that point. And there's also no evidence that having that support group as set up would necessarily be the best interest of the child. I mean, kind of look at this and it's kind of devoid as to the best interest of the child. I don't think the court really addressed, I mean, this is what I think is best, and here are the reasons. And these decisions can't be made in a vacuum. I mean, the legislature has stated, here are the things that are relevant, here are the things that you need to look at, and it must be a balance.
So we can't tell that those other two factors aren't what tipped the scale.
There's no way of knowing, and there was no evidence for it. Thank you, Your Honors.
You have any further questions?
Yeah, just one. I'm sorry to be so thick. You're not disagreeing with the concept that you can have a future change of custody, but you're saying that here it couldn't be done because we don't know what's going to happen in the future. So what would be the base, if you're not basing a future change in custody on the facts you know today, then what would be the basis for the future change of custody? You understand what I'm asking you? You say, well, it's okay to do that, but you can't do it unless you base it on what the facts are going to be in the future, and I guess I don't know how that works.
Well, I don't necessarily know how it works either, Your Honor. I'm not advocating that as a position. I'm saying that I think the law would allow for the court within its discretion under the right evidentiary backing to make such an order. I'm not saying that this is unconstitutional. We're not arguing that it should be excluded in all cases. But I'm also not saying, Your Honor, this is the way it should be. I'm not advocating future decisions like this. I disagree with it. I think it's wrong. Let me be absolutely loud and clear. I think this is ridiculous to try and predict a 2-year-old to a 5-year-old and what's going to be best for them, especially when that hasn't been the issue before the court. And I would say, as reviewed by the Court of Appeals,
But isn't that done all the time? If they'd have had residential custody with your client right now and says, okay, that's my order, that's predicting that's gonna be in the best interest of the child, when that, 3 years from now.
no, Your Honor, it's a finding of the best interest of the child today.
Right, but
And where they think it will go.
assuming it's gonna be the best interest of the child in 3 years, 5 years, 10 years, until there's a motion for change of custody based on the change of, material change of circumstances.
And maybe we're apples and oranges today, Your Honor, but I disagree with that. I think the finding is for the best interest of the child based on the evidence and placement at that time, with an anticipation and hope that that is the correct answer. It is not, this will be good for 3 years. This will be good for 10 years. This is the child, their circumstances, their parents' circumstances, based upon the evidence at that time. The beauty of the continuing jurisdiction is, while we may hope for the best doesn't always work out. And if things go to heck in a handbasket, they can go back to court and petition to make that change. It's not a set, well, we were going to do this in 3-year increments and we'll come back in 3 years, because that's how we would do it if we were working on that future basis. We wouldn't allow continuing jurisdiction. We would say, okay, we're just going to review this every 3 years and see how the kids are doing. But we allow the parents to make a determination about whether they think things are best for their child, or if there's been a change, or if there needs to be a change. And I think that's how the system works. We're always hopeful that the children are going to get the best they can, and that's going to last for as long as possible. But it's an imperfect world. We have many imperfect parents, and things are going to change. But it's up to the courts and the parents to determine when those changes need to be addressed.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
You reserve 2 minutes for rebuttal.
Thank you. The standard of review, I agree, is abuse of discretion. As we pointed out in our briefing, we do not believe that the Court of Appeals followed that. We believe the Court of Appeals used substantial competent evidence standard and cited criminal cases as authority, and we feel that this order was well within the court's discretion. I'll try to limit my remarks here to things that counsel just said.
Well, Counselor, currently, our statement of abuse of discretion includes the circumstance where the facts upon which that discretion was exercised are not supported by substantial competent evidence. So it's sort of all the same thing, isn't it?
If they're one and the same, then so be it. But I looked at those cases, and I felt they were two different things. I felt that the substantial competent evidence applied more to criminal, cases. But
And could you address for us why there is substantial competent evidence to support the court's finding in this case?
yes, I think there was a great deal of testimony comparing the support systems that the two parents had, the communities where they lived, the parents' parenting styles, the conflicts between them, and the court ultimately decided not just on 2 reasons, as counsel stated, but the court found that there was a wider support system generally with the father, and that included family and friends of the child. The child's acclimation to the community over the last 2 years of the child's life.
What does that mean for a 2-year-old?
Acclimation, happiness, comfort.
Is that any different, though, than the support of the family or the circle of friends for a 2-year-old? Is it just saying the same thing again?
Well, I think it's how the child, the court heard a lot of evidence how the child reacted to situations, to groups, to settings, to activities. I think there's some difference, and of course it's separated in the statute. So there must be some little difference there. There must be some difference of some sort, but certainly they dovetail. Certainly they cross over. And then the family. The family was a big support factor, and the stability of the family support system. And counsel mentioned that there was equivalent evidence presented by the mother. Well, there was quite a bit of evidence presented by the mother on that point, and frankly, the judge was very kind to the mother because that evidence indicated great instability. These parties were separated for an extended period of time. Mom moved from friend to friend to friend in Garden City, then moved to Dodge City, and the parties continued to share every 4 days, every 3 and 4 days, back and forth. And then just weeks before trial, mother moved to Winfield, reported to Kelly, the petitioner, my client, when she was in that location and it was time to exchange the child. He asked, "Have you moved?" And she said, "I'm just here celebrating my birthday or celebrating a holiday." And then it came out at trial that she had in fact moved. So yeah, there was a lot of things the court could have found that would have been very unkind, but certainly the stability factor, as supported by the family, pointed to the father in this case. The counsel made a comment about the parties were not put on notice. I'm telling you, parties in custody cases, as we all know, are on notice that they need to put on whatever evidence they think supports their position. That's your chance to do it, and you've got to do it. Counsel made comment that his client was trying to get back into court and was being barred by the district court. I have absolutely no knowledge of that whatsoever. There has not been a motion filed. I have not received a word, to that effect. I have no knowledge of that whatsoever. Counsel made comment about the Perry case. I think he meant the Smith case. It was the same district court that was reversed for insufficient findings. He said the court made no findings in that case. The court made the same order that he made in this case, but he made no findings whatsoever as to why he selected one parent over the other for the residential parent at the time of school, and that was what the court found fault with. In the same decision, the court goes out of its way to say this is a perfectly fine order. This is well within the court's discretion to make this order to take effect when the child reaches school age, but you've got to make findings as to why you select mom over dad or dad over mom. So, any other questions?
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.